The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Before we get started, we want to make sure that our audio is working okay. So if you can hear me, it lets me know that you can hear me by raising your hand. Great, thank you. All right. One second. Okay, welcome and thank you for attending the Colorado Medical Board stakeholder meeting via webinar. Today is October 25th, 2021, and the time is 3:31 p.m. Before we get started, we would like to introduce the staff members from the Division of Professions and Occupations that are present. My name is Darcy Magnuson, and I'm a regulatory analyst with the division. Also attending is Paula Martinez, Program Director, Elena Kemp, Regulatory Coordinator, and Dimitri Kunin, Senior Program Director, should also be joining us. Due to concerns regarding COVID-19, the division has transitioned to a platform that is 100% virtual, and we appreciate your flexibility. As many of you have been to DORA stakeholder meetings before, we would like to reiterate the importance of your comments today. DORA makes decisions every day that may affect your life and your business, so your input is vital in the rulemaking process. Throughout this process, our goal is to create regulations that clarify and explain legislation, ensure minimum competency to enter and continue to practice, and provide only what is absolutely necessary for consumer protection without creating unnecessary barriers to the marketplace. Your input will be part of the information that goes to the board as it considers adopting revisions to the rules. More specifically, we will be discussing revisions to Rule 120, 3 CCR 713, Section 22, to implement Colorado House Bill 2013-26, titled Concerning an Expansion of an Individual's Ability to Practice an Occupation in Colorado through creation of an occupational credential portability program, and the proposed new rule, 3 CCR 713, Section 49, to implement Colorado House Bill 21-1276, titled Concerning the Prevention of Substance Use Disorders. This meeting is being recorded and will be posted on the board's webpage by the end of business tomorrow. As this stakeholder meeting is held solely by webinar, please raise your hand by using the hand icon if you would like to speak, and we will unmute your line so you'll be heard by everyone. Or you can type your comment in the question section and we will read it aloud. For anyone that is planning to provide comments, please state your name and who you represent, if anybody. Feel free to provide either general comments on the rule changes or specific comments on the proposed language. Keep your comments limited to 3 to 5 minutes or less, and try not to repeat something that was already said. Stating you're in full agreement with someone else works just fine and will be noted. As far as ground rules or housekeeping matters, if you are using audio through your computer, please remember to put any phones on vibrate or turn them off. And whether you are using computer or phone audio, try to keep background noises to a minimum when speaking. So at this point in time, we will begin taking stakeholder comments regarding Rule 120 and the proposed changes that relate to the implementation of House Bill 2013-26, the Occupational Credential Portability Program. So if you would like to provide stakeholder comments, please raise your hand and we will unmute your line. Or you can type into the comment question function and we can read your comments out loud for the recording and for other stakeholders. All right, I see Sierra Ward. You are unmuted on our end and your end, so we should be able to hear you.
Very good. Good afternoon, Darcy. Again, my name is Sierra Ward. As I mentioned at the last stakeholder meeting on this topic, I'm a healthcare attorney here in Colorado, and I have represented clients who have faced barriers to licensure in the state due to having a practice focus in administrative medicine. Prior to today's meeting, we submitted some proposed revisions to Rule 120, and I'm primarily attending today to address any questions that you may have about those revisions. But very briefly, our intent was to specify that the practice of administrative medicine constitutes the active practice of medicine, and that physicians who are engaged in the active practice of administrative medicine are entitled to a full and unrestricted license without any need to demonstrate continued competency. This proposed change puts administrative medicine physicians on par with physicians of all other practice specialties who are granted full licenses that do not contain any practice restrictions. As I discussed last time, there are already systems in place to ensure physicians will remain within their scope of practice, such as credentialing bodies, employers, patient choice, and the board's own regulatory authority. Along those lines, our changes also make clear that a clinical practice is not required to obtain a full and unrestricted license. Some of the most highly qualified and well-educated physicians function exclusively in an administrative capacity and have no direct involvement in the provision of clinical care, but their roles nevertheless still require a full and unrestricted license. Our final proposed substantive change was to include a definition of administrative medicine, as that term is not defined elsewhere in statute or regulation, and the intent of adding that definition was to ensure consistency in application. And I don't have any further comments, but as I indicated at the outset, I'm more than happy to answer any questions that you might have about our proposals.
Thank you. I don't have any questions for you. I don't know, certainly if any other stakeholders have questions, that this would be an opportunity to ask too. We certainly want to facilitate conversation regarding these proposed changes in advance of the board's consideration at the meeting on November 18th. So we'll see. I do have someone else with a hand raised right now, so we'll move on. But if stakeholders do want to communicate back and forth, that this is certainly a forum for that as well. So I'm going to go ahead and place you back on mute and then move on to the next person. And like I said, we can continue the conversation depending on what the next person has to say. So thank you. So I show Dr. Anthony J Van Gor. Your hand is raised and you are unmuted. We should be able to hear you.
Yes, very good. This is Dr. Anthony Van Gor from Loveland. Can you hear me satisfactorily?
Yes, we can.
Okay, very good. Thank you. I'm looking at the provisions that are put forth in this regulation. I certainly agree with the prior speaker with respect to administrative medicine physicians. I have been one for some time, and I am aware of the present requirement that such an administrative physician have a license, and I appreciate consideration of what the prior speaker said. The regulations, you've actually scrolled down from the part of the regulation that I'd really like to talk about. If you could scroll back up, I'd certainly appreciate that. Okay, very good, thank you. It's in this area right here. My read of the Occupational Credential Portability Program as set forth in Colorado, the CRS, indicated that there was to be no specific requirement of actively having practiced medicine for a 2-year period immediately preceding the filing of the application. And I'm wondering why it's appearing here again. Is it set for deletion, or is it going to be put into place? And also, this program, if this indeed stands, the regulation that you're putting forward, or the policy you're putting forward, doesn't specifically talk about how that a person can demonstrate competency if they haven't practiced in the 2-year period beforehand, whether or not they have to go through the Denver program at considerable cost, or if there's some other mechanism that's made available.
Thank you, Dr. Van Gor. I will do my best to answer your question. So the text that you're seeing there that's in the redlining is a proposed addition. So basically that was taken from the board's current policy and added in here just for the board's consideration. So none of this has been adopted or anything by the board. What the board wanted at the last meeting, so the board reviewed this at its last full board meeting in August. After the board had had already had a stakeholder meeting, and the board wanted to get additional information from stakeholders. So really this language in here is just up for consideration, and I do appreciate your comments regarding the proposed language. None of it's final, and the board will review it again in November and decide whether to adopt it, make any changes. So your stakeholder comments are certainly helpful for the board.
If I could make one other comment about that, if this indeed stays in, this is in addition to what the specific Occupational Credential Portability Program Act really does say, and I think it might overstep the authority of the board to put this in. So as far as that's concerned, I want that to be considered seriously if this is continued.
Thank you, Dr. Van Gor. I appreciate that. I am going to place you back on mute and lower your hand. If you want to speak again, feel free to raise your hand. Sierra Ward, I see your hand is raised. You're unmuted.
Darcy, just a quick question based on the last speaker's comments. That portion right there, talking about the active practice at the very end, is that intended to apply to applicants by endorsement, or is it just intended to apply to applicants who are applying for reinstatement?
According to how this rule is written, it's under the section regarding endorsement. So
okay, because it says the reinstatement of an expired license who have not established that they have actively practiced medicine for the 2-year period, etc. So I was just wondering if that clause right there is only intended to apply to reinstatement, which that it's certainly one reading of that sentence. I would just articulate, I'm not sure, I understand that the Occupational Credential Portability Program does address endorsement only, but I think that the comment that was raised should apply equally regardless of the form of application.
Elena, will you note that, add a comment there about the reinstatement so that that can certainly be reviewed by the board to clarify?
Yes, this is Elena. I was just looking through the rules as you guys were speaking, and I'm not sure the subsection of where the comment should be. I don't. Maybe
it's right above 22.2. So where it says it's a little bit above where you have it scrolled to right now. So you need to scroll up a little bit. So if you look at paragraph B there, what we're talking about is the third sentence from the bottom, that last portion right there. It's not clear whether it's intended to apply just to applicants by reinstatement or if it's intended to apply to all types of applicants. And my point was just that there's really not any logical reason to treat someone differently if they're applying for reinstatement versus by endorsement.
So really, if you hover over the reinstatement section, yeah, and then just add a comment there. And the question is about the applicability of this particular regulation and whether it applies to reinstatement or it just applies to endorsement.
But that was, I think, a backwards. So whether it just applies to reinstatement or it applies to all applicant types, because it follows the reinstatement portion.
Okay. I won't meet you again, Sierra, until you can take a look at the written comment here and see if we have it correct.
Okay. Yeah, that looks good to me.
Okay.
Thank you.
All right. Feel free to raise your hand again if you want to add anything else. We do have others participating. I don't see any other hands raised at this time, and we haven't received any written comments. So before we move on to 6 regarding, so I'll just pause. advance of the rulemaking hearing that's currently tentatively scheduled for November 18th. Sierra, I see your hand was raised, but it looks like you lowered it. All of that information is on the board's website under the Public Notices tab, and then you'll see links there to the stakeholder meetings, as well as the current draft rules. We do update with stakeholder comments, so you can find all of the information on the board's website. Okay, I don't see any other hands raised, and we do have a fairly small group of people participating today, so we're going to go ahead and move on to House Bill 21-12-7, or sorry, I think it's confused House Bill Senate Bill because we have so many, but 21-1276 regarding benzodiazepines. And if anyone wants to provide any comments regarding these proposed changes to the proposed new rule to implement this legislation, this is your opportunity to do that. And this particular rule will be considered by the board on November 18th for potential emergency and permanent adoption because of the language in the legislation requiring the board to implement this law and adopt rules by a certain date. So the board will be considering this for both emergency and permanent adoption at the meeting on November 18th. This particular legislation also impacts the prescribing boards, and so the Colorado Medical Board will actually be the last board, the same day that optometry will consider this for potential adoption, last of the prescribing boards to adopt this new rule. So I don't see any hands raised, and no, we haven't received any written comments. I did mention earlier about providing written comments via email. I want to make sure that folks have the email address, which is dora_dpo_rulemaking@state.co.us. It is included on all of the notices that we send to you about stakeholder meetings and rulemaking hearings. Same notices that are posted on the board's website and also on the board's calendar. So I think it's important to continue to get stakeholder comments, especially with respect to the first rule that we talked about, because the board was very clear at the meeting in August that the board wanted to get more feedback from stakeholders regarding potential changes to Rule 120. Okay, I'll just wait for a couple more minutes and continue to monitor and take a final call for stakeholder comments regarding either of these rules. So I'll just pause until 3:52, and if no one else wants to provide any comments, then we will go ahead and talk about next steps, which I've already discussed briefly. Dr. Van Gor, I see your hand is raised, so I've unmuted you.
Okay, very good. Thank you. The meeting to 120 is on, again, the 18th at what time?
Let me look at my calendar because I don't remember off the top of my head. We have two that, so I think medical, let me clarify though for sure, is scheduled to start at 11:15. Elena or Dimitri, if I'm wrong, let me know. I'm pulling it up right now.
No, you're correct, Darcy. 11.
Okay.
And that's associated with the normal quarterly meeting?
Correct. It's during the full board meeting. And stakeholders will have a final opportunity to testify, and then the board will decide what, if any, changes to adopt at that meeting.
Okay, very good. Thank you.
Okay. I don't see any other hands raised. And we haven't received any written comments through the chat question function. So I will go ahead and wrap up the stakeholder meeting. Thank you again for participating in today's meeting. The stakeholder comments and program recommendations will be presented to the board prior to the rulemaking hearing, which is scheduled for November 18th, 2021. That concludes the stakeholder meeting. We thank you for your participation, and we will be ending the webinar now.